Good morning.
Morning.
I'm passing around a 2.5-page summary of what I'm about to speak about so that you can take that away with you today. And also you have a smaller document that you can look at which kind of summarizes the presentation this morning. I've also asked Rachel to email to you all the same document because I know the chairperson is going to ask if we can have it electronically. Just a brief history, if I can, before we get into the meat of the discussion. Back in 2009, the state legislature amended the statute in terms of regulation of the expenditure of public funds in campaigns. When that occurred in 2009, PSTA board authorized me to make a request to the Division of Elections for an opinion with regard to the interpretation of that statute. During the time that the Division of Elections was considering the response to our request, the legislature amended the statute and kind of bounced back and, in a way, deregulated the expenditure of public funds on referendum campaigns. They then issued their opinion, and it's mostly the opinions that the Division of Elections has that provides us guidance as to the interpretation of the law as it exists today. The other point I wanted to make sure everybody understands is there is, and I'm going to try to point out, some real misunderstanding about the state of the law today and the limitations on the expenditure of public funds on referendum campaigns. And I'll try to point those out as we go. The first thing you need to understand the state of the law is to know what is a political advertisement. A political advertisement is specifically prohibited in terms of an expenditure of public funds. You cannot expend public funds on a political ad. There's two things that make up a political advertisement or make something a political advertisement. First of all, it has to be a paid expression in what is described as a communications media, which is pretty much what you would take it to be: a TV station, radio, newspapers, direct mail, payment to place it on an internet site, periodicals. The second part is that political ads are ones that expressly advocate. And this is a term that we'll talk about. What does that mean in a moment? The other important part about a political advertisement is what it excludes. It excludes expression by spoken word in a direct conversation, which basically means that anybody on this, sitting on the dais, Mr. Miller, or anybody at PSTA, is free to speak to another person, to the media. As long as you're not paying the media, you're free to speak and say that, provide what we'll describe in a minute, what is expressly advocate in favor of the referendum. There's nothing that prohibits that First Amendment right for any member of the board or Mr. Miller or anybody at PSTA to speak your opinion. If you go to Tiger Bay lunch, you may, and Mr. Miller may speak his opinion that he suggests that people vote in favor of the referendum. Hey, it's only if you make a paid expression in the media. So what does expressly advocate mean? Expressly advocate is the Supreme Court has used what is called the magic words. The magic words that would get PSTA into trouble is specifically, and is pretty limited to things such as vote for the green light referendum, support the green light referendum, cast your ballot for the green light referendum. Okay? Those are the type of magic words that cannot be used in a political ad. It becomes a political ad. I mean, that is paid for.
Definition.
That is a U.S. Supreme Court definition.
Okay.
That is that PSTA cannot pay for, or any of your governmental agencies that you work for cannot pay for. The private sector can pay for those ads, but PSTA cannot pay for a political ad that uses those magic words. Briefly, I kind of briefly mentioned this, communications media. It does include the internet. It does include an expenditure for the cost of creating or disseminating a message on the internet. It can be a paid expression. The Division of Elections tells us there must be a direct cost involved. in order for something that goes on the internet to be considered a paid advertisement, that would be prohibited under the statute. The Division of Elections has also told us that internet service provider fees are not considered direct costs. So the statute also tells us what is an electioneering communication. And I go over this definition because electioneering communications are now permitted. In other words, you can use public funds on electioneering communications. Electioneering communications differ from a political advertisement in two main ways. There's no payment to put it into the media, and it doesn't expressly advocate. If we go to the next slide, it kind of gives you a table that shows the distinctions between the two. Political advertisement expressly advocates, uses those magic words. It's somebody pays to place it in the communications media, and so that is prohibited. Electioneering communications are distributed by the media. They're not paid for to be placed in the media, and they don't expressly advocate. So I want to talk a little bit also about one of the other distinctions, and this is where one of the misunderstandings about the state of the law comes in. A lot of times you'll see in the newspaper and you'll hear people say, PSTA can only pay for factual information. And the way factual information, and I'll have a slide on this later, is defined is, under the law, is it's something that's verifiable. So you say that with the money, PSTA will buy 100 new buses. That's verifiable. That's a verifiable fact. You can say that PSTA will reduce headways on 10 routes by 15 minutes. You can say that PSTA will provide night service until midnight, Monday through Friday. Those are verifiable facts. The in-between expressly advocating and factual, verifiable facts is what the Division of Elections refers to as subjective comments, such as bus service will be transformed in PSTA. PSTA will improve bus service tremendously if the referendum passes. Those are subjective comments that are permitted now under the state of the law. Okay, and that is one of the points I want you to take away from today's presentation, is those comments, because generally out in I've seen emails, I've even seen comments in the newspaper that you're limited to these verifiable facts. That's not correct. You can disseminate information. PSA can use public funds to disseminate information that has subjective comments in it. It just can't go that next step and expressly advocate how somebody should vote in the referendum. So this slide is just a summary of basically what I just said. And again, the main thing I want you to take away from this is that PSA can fund communications that make subjective comments, that bus service will be vastly improved, as an example. One of the things I do want to point out is prior to the adoption of the statute that presently exists, it was adopted in 2009, then amended in 2010, was that we had an Attorney General opinion that indicated that it would be best if governments that want to expend funds on those electioneering communications, that they make legislative findings supporting those expenditures and indicating the public purpose or the purpose of those expenditures. So it's one of the things that we might consider doing before PSTA can expend public funds, obviously all your funds are public funds, on such communications. Then we should probably consider adoption of a resolution supporting generally the use of such funds in that purpose. To meet the Attorney General's old opinions, again, that with the change of the law in 2010 may be, again, relevant. Public agencies are permitted to spend funds on political ads that are limited to factual information. So this is where we go back to verifiable factual information. If we pay for an ad in the newspaper or on TV that relates specifically to the referendum, then that we are limited to factual information. I always like this slide because you hear a lot of the public will say to you that it's not right that you're providing your opinion or that Mr. Miller's providing his opinion. The Florida Supreme Court has actually told us that you not only have a right to do that, you have a duty to do that. In a case involving a referendum back in the 1990s in Tallahassee, they said that public agencies have an inherent duty to say which course of action is best for an agency to follow. This is the purpose for which we elect government leaders. So the Florida Supreme Court is telling you, the elected officials and other board members, that you not only have a right, but in a sense you have a duty to tell the public what you think about the Green Light Pinellas referendum. Again, I kind of already went over this, so I'm going to skip that slide. Who can express opinions? Again, in the spoken, in terms of providing spoken word, all of the elected officials and other board members are free to express their opinions on any matter. The only limitation you have is you cannot pay the media to print those opinions. So if you are called in, any one of you are called to express an opinion on the referendum at a public function or at an editorial board meeting, you're free to do so. Okay. And that goes for government employees as well, and those of the board members, we only presently have one, but we typically would have two non-elected board members. The same goes for them as well. Mr. Miller can speak to the media if he's going to be interviewed by the editorial board or by a reporter. He can give the reporter his opinion, again, so long as PSTA doesn't pay funds for that to be printed in the newspaper. I know there is a movement to have a political action committee formed, may actually already be formed. So I just wanted to make sure that the elected officials are aware of the statutory prohibition on you participating in a PAC. You can be involved in an uncompensated capacity. So if you wanted to be a member of the PAC or be involved in the PAC, you can, so long as you don't receive compensation. In terms of seeking public contributions, obviously PSTA, I think everybody probably understands this, is prohibited from making contributions to the Political Action Committee. I tried to create some scenarios that kind of maybe show you how the application of these principles that I've been discussing might apply as we go through the campaign process. The first one is speaking to the editorial staff. This is allowed, again, if any of you are called, including Mr. Miller are called or Cassandra's called to speak to the editorial boards, that is permitted, again, because you would not be paying the editorial boards of the newspapers to print your opinions. Can PSTA use things like their copy machine to copy material which contains opinions regarding an issue or the referendum? This is considered to be expenditure of public funds, but it's permitted so long as what you're not copying is something that then is going to be paid to be put in the newspaper or on TV or other form of media. Same thing goes for use of PSTA equipment such as computers. Mr. Miller or staff would be allowed to use PSTA computers so long as they're not creating material that expressly advocates and is going to be paid to be printed in the newspaper or other form of media. Internet usage gets a little bit more of an unsettled situation at the present time. It's somewhat unclear as to what exactly would constitute a direct cost when it comes to placing items on the internet, and there is a Green Light Pinellas website. My recommendation is to keep our communications on the Greenlight Pinellas website to either verifiable factual information or that subjective comments, and not go into the ones that expressly advocate. Like I said, the state of the law is unclear. The Division of Elections has not really been that specific as to what would constitute a direct cost that would be prohibited. For example, it's unclear to me whether paying for the domain name would constitute a direct cost if there was something on that website that expressly advocated in favor of the referendum. So my recommendation is to not cross that line, and everything I have seen and that Mr. Miller and I have discussed have not crossed the line, and we have not gone into expressly advocating. Use of the telephone, again, it's basically the same thing as the others, as long as not a specific telephone that we were to purchase in order to advocate, expressly advocate for the referendum, then that is not a prohibited expense. Can Mr. Miller use a PSTA vehicle to drive to an event and where he's going to speak and expressly advocate? He can do that because it's not considered, his public speaking is not considered a communications media. So if he goes to the Tiger Bay Club and he speaks to the Tiger Bay Club and he drives there in a PSTA vehicle, that's permitted. Okay. So that's the end of my presentation. Again, I think where the misunderstanding is, and what I want to make sure you take away, is the understanding of what is a political advertisement, which is prohibited, and then where the line is drawn is you can make subjective comments, you can use public funds to make subjective communications. The Greenlight Pinellas is going to be transformational for Pinellas County. It's going to create jobs. It's going to improve bus service. It's going to create a rail line for the first time in Pinellas County. I guess that's a fact. But things of that nature are where the line, where we've been trying to hold the line and not go over and use what the U.S. Supreme Court has called those magic words, where you directly are informing or telling the public, this is how we want you to vote.
Thank you,
Does anybody have any questions on?
Very informative. We do have some questions. Let me just ask you one to lead off. So if we wanted to put an ad in the Trib or the Tampa Bay Times or online that said, Greenlight Pinellas will, and talks about the improvements in bus service, the rail plan, the expected jobs, and well, could we put one in that talked
Yes.
about those three things? Could we put a line on there that talks about the expected elimination of the ad valorem tax?
Yes.
Okay. Commissioner Barkley?
Thank you. Alan, good presentation. Thank you.
Thank you.
My concern is with regard to the groups that are operating already. They're already, matter of fact, there's an article in the paper today about that, already operating and disseminating a lot of information, some of it's disinformation. And my concern is, can we expend funds to correct or countermand or otherwise correct disinformation or misinformation that is being put out by groups that are opposing the Greenlight Pinellas program?
Yes, again, as long as you don't go that extra step and expressly advocate, you can include factual and subjective information. Just can't go that last line and put at the end, vote for, referendum item number 2 or whatever number it's going to be, or vote for Greenlight Pinellas.
Thank you, Commissioner Barkley. Commissioner Rice?
Yeah, thank you, Alan. On the last slide under the scenarios, I think it was the last slide, is the allowance for a staff person or a PSTA board member to be able to voice their opinion and support for or against the referendum, is that generally protected under free speech, freedom of speech case law, or is there, what's giving us that room to be able to speak?
It's a First
freely?
Amendment issue, and honestly, I think What happened in 2009 was there was a case out of Broward County where the court, without addressing specifically the statute, talked about the freedom of speech issues that this type of legislation was affecting, and came out in favor of the right of free speech of elected officials and government employees. And that's when the legislature went back and changed the statute to try to address that case. So it is a freedom of speech issue.
I have a couple
Yes, ma'am.
more questions. Also, in regards to either a PSTA staff person speaking in favor or against the referendum, or a PSTA board member who may be at an event where part of the event is paid for by PSTA, isn't that a pretty gray area if there's a staff person's time being paid for while they speak on the...
Not according to Division of Elections. If you're just talking about paying, well, of course, Mr. Miller's on salary. He doesn't get paid anymore if he goes to the meeting at 8 o'clock at night, or if it's during his regular hours. But the Division of Elections looks at that as an indirect cost. They don't look at that as a specific cost that you are paying for Mr. Miller to attend that meeting and express his opinion in favor of the referendum. So that is allowable.
And on the use of phones, if the purpose of a phone call from PSTA would be for the express purpose of lobbying or advocacy, and the caller ID number shows up as PSTA, isn't that a gray area as well?
No, according to the Division of Elections, that's okay, so long as PSTA doesn't set up a specific phone and pay an additional amount of money than it already does for its existing telephone service in order to allow a staff member to make those phone calls. But again, I think what we should, well, that's an indirect, like I said, that's not prohibited. When we go outside of using already existing equipment, already existing facilities or services, then we need to stay away from expressly advocating.
Commissioner Rice, you have another?
I'll wait.
Okay, Commissioner Newton?
Well, basically, you can't use the taxpayer money to influence the outcome of a vote. That's what they're after.
See, I would disagree. Influence to me is too broad a term. I think people would tell you, and certainly people in the business of running campaigns probably know a lot better than I, that even expressing factual information about what Greenlight Pinellas will bring to Pinellas County, some people might think that influences the vote. So I think that's too broad. I think it's more direct. You cannot direct or tell somebody how they should vote or that they should support Greenlight Pinellas. The word influence concerns me. It's just too broad and too open to interpretation.
Well, what I was getting at was the utilization of public funds to that end. You're spending money to get them to vote a certain way or to advocate for a certain thing with that money. That's why you keep saying, long as there's no special phone line paid for or set up, just for that sole purpose. So it's all back to the money.
Right. Well, if there's no public money involved, then you're free to express your opinions, as is Mr. Miller and any other PSTA staff member.
Okay. Thank you, Commissioner Newton. Commissioner Dighton?
Yeah, as I understand it, then, the key word in this is "and." So you can say, vote for this, vote for the Greenlight Pinellas, but you can't pay to do that. And you can pay to have some sort of a explanation of what's going on, and that's fine as long as you don't say, vote for. So it's the combination of the two. So you can do either one of them without the other and not worry about legal implications.
Correct.
Okay.
Thank you, Commissioner. Commissioner Maroney?
Thank you, Alan. Great presentation. What are the penalties associated with this and the enforcement procedures?
That's a good question. I'll have to get back to you on that because I have not found any either division of election opinions or cases where this has been attempted to be enforced. Again, I understand this has only been in effect since 2010.
Okay.
So I'll have to go back and see what authority division of elections is given specifically. If I can get back to you, I'll send out an email to the
Might as
entire
well share
board.
that with everyone too on
I
the
will.
email. Thank
I
you.
will. Thanks.
Thank you, Commissioner Maroney. Commissioner Johnson? Yes, I'm ready.
Just to be real clear, and I'm not saying I would do this, but if before the referendum, I, as a person, took out an ad in the Tampa Bay Times urging people to vote for it and had the appropriate disclosure statement on there, not using PSTA funds, not using public funds, is that permissible?
Absolutely.
You're a pack.
Right.
I mean, if you're using private funds, then, there are regulations over the use of private funds, but you can use private funds for advertisements that expressly advocate.
Thank you.
Thank you, Mr. Vice Chair. Commissioner Rice?
I had a follow-up to Commissioner Maroney's question, was a clarification of whether if we inadvertently spoke in favor of this referendum when we weren't actually supposed to, are we individually culpable, or do we put PSTA at risk?
Well, it's the expenditure of public funds
Okay.
that so it would be, and again, I'm going to go and take a look and see if the Division of Elections would have any enforcement action that they could take against an individual. But because you only cross the line if you expend public funds, my thought is it would probably be a PSTA issue and not an individual issue. But I want to get back to you on the enforcement issue.
Thank you, Commissioner Rice. Brett?
I would just like to make some comments just about sort of in follow-up to this. I mean, I asked Alan to give this presentation because I think myself, I think almost probably every PSTA board member has asked questions about exactly what this is about. Alan actually originally made this presentation to the Florida Public Transit Association board of all the transit systems in Florida, because there's a lot of misinformation about this. As it pertains to you all and the PSTA board, my goal of the presentation was for Alan, and maybe because he's a lawyer, maybe this is impossible, but to give you comfort that we are working very hard to be nowhere near crossing the line or getting you in trouble in any way. And in fact, I am going to be coming to you over the next several months and asking for your assistance, that you as elected officials can speak to on this issue. And I'm going to ask you to do that, to go out with me to cities and presentations and out there. As Alan said, it's obviously something that the PSTA board that you sit on has voted for, and it's something that I think we need to do if we are supportive of this.
Well, again, this is a great idea, Brad. Thanks for having Alan put this together. We have to advocate for this as individuals. We asked the commission to put this on the ballot. We have to have ownership, and I'm glad you confirmed that we as individuals can go back to our communities and countywide and advocate that, yes, this is good for Pinellas, and talk about why folks should vote for it in our individual capacities, not using PSTA funds. If we don't do that, this doesn't win. But also, we're getting more support. I think you were at 2 commissions last night that supported this, Treasure Island and Largo. So there'll be elected officials from around the county who can go out in their individual capacities and tell folks why this is important in our circles, in our neighborhoods. We have to do that. Really the same way that we approached Penny for Pinellas several times, going back to your communities and telling folks, yes, you should vote for this. Now, as PSTA using public funds, I think we do have to have some kind of a fact-based information sheet, whether it's in the Times or on the web or whatever, that says this is what Greenlight is, this is what it will bring in terms of bus service, rail service, jobs, whatever. Because there is a lot of misinformation out there, and you've got to, if you don't fill that void, then we're not going to be successful. So I do think within the parameters that Alan laid out, that we need to do that at some point. My question would be, do we have a plan to do that? Does this fall under planning, or how do we get from here to there so that we've got some documents that we can have out in the community to tell what Greenlight is, what the benefits are, and what the costs are?
We do have a number of initiatives underway to put those sorts of materials together. Right now, we are compiling, I think our planning department is calling it the box set of all of the plans in all of their glory. The bus plan, the rail plan, the Greenlight land use stuff, all that stuff together into a combined package to get out to libraries and on the internet and the public. They're working very hard on that. We are trying to focus this spring on making the rounds to these 24 municipalities and chambers of commerce and other groups. We are collecting endorsement resolutions. And really to make that more effective is this idea of engaging you all as elected officials representing your constituents to come to join us in that. The private campaign is getting going probably at the very end of this month, and then that will be an additional sort of avenue that will have it maybe do different sorts of ads. But it's still very important. It'll be very important throughout until November, and then even beyond for the elected officials to show leadership on this.
I've got some other comments, but I just want to ask the board members, is everybody comfortable with what I laid out in terms of us getting the facts out there to the community? Does anybody have any heartburn on that? Okay. Let me get Commissioner Long, Newton, and Maroney.
Yes, thank you, Mr. Chairman. And Mr. Zimmet, please don't take offense at what I am about to say, but I have been really quiet listening to all of the dialogue right here. And I feel a responsibility to share with all of my colleagues that it was myself and Commissioner Justice that passed this bill in the Florida legislature.
Yes,
and
you
the
did.
intent was to not have government agencies suing other government agencies with public taxpayer dollars because one agency didn't like what the other agency was doing. And there was never any intent in the law, the discussion on the floor, or in committee about keeping elected officials and leaders from advocating or talking about positions that they're representing and or voting on in their capacity as an elected official. It was the attorneys after the law passed that started raising all of the ancillary issues that we've been talking about this morning. So as public officials who've been elected by the people, part of our responsibility is to educate. And then all of this discussion, I really haven't heard that word brought up in terms of how we talk about it, how we message it, and how we get it out to our citizens. On any issue, any big global issue that affects a multitude of people, there are always going to be those people who are very passionate about why we need X, Y, and Z. And there are always going to be those people who disagree. The key to bringing collaboration and consensus to everyone is to focus on the facts, because while you may not like something, you have every right in the world to say you don't like it and you don't want it. But you don't have a right to make up your own facts about what the reality is. And we all know, we've been around, most of us, for a long time, perception becomes reality. If you say something often enough to a group of people, whether it's true or not, it's almost like brainwashing. People end up believing it, when in fact, the real truth could be very, very different. So my position as an elected official is we have a huge responsibility to tell the truth, to tell the facts, and to educate. Because, as we all know, this is a very, very complicated issue. And the people that are going to be voting on this have not had the benefit of sitting through hours and hours of the meetings that we all have, number one. And number two, they've not had the opportunity, most of them won't have taken the time to read the thousands of pages of documents that explain it all. So how else do they get the information if those of us who are the most educated on it aren't talking about it? So I didn't mean to be so long-winded, but I did feel a responsibility to take ownership in the mess that we created.
And that came out of the annexation wars, right, over the
Yes.
charter review?
Absolutely. Thank you for remembering that.
Oh, yeah, it's ingrained in my memory. Commissioner Newt?
Thank you, and thanks for that disclosure, Commissioner Long. It's another unintended circumstance that normally happens out of Tallahassee. It'll take on a picture of its own. All I would add to that is educate is paramount, but also to advocate. And I hope that we wouldn't leave out the effect, the real effect. You heard people talk about this morning how buses are backed up and we need more buses, should do this, should do that. We need to lower prices so everybody can ride free or almost free and all that. And what's going to happen if we don't go out and educate and get the people enough information to make an informed decision when they go to the ballot box? As representatives of this transportation organization, it's our moral obligation to make sure that we provide for them the information. So if the latter happens and we end up cutting this bus system that everybody's complaining about, this transportation and how bad it is and how bad routes are, in half, try to envision that. You're complaining about what we got right now, but just in half because of what we have. You just saw a study put out by, that was commissioned by the legislator, that was done by KPMG, and it came back saying that both of them are doing everything, and some of them are doing multiple jobs with what they got. But what they got is not enough. You hear the people come in constantly wanting more and wanting us to do more with what we have. And we're doing just that according to the report. But if you don't have a source to be able to sustain it and to grow it and to be able to accommodate the needs of transportation for the people that use it, and also the people that's going to need it, the ones that's going to be not able to drive. When they get up there, you make a decision on, do I take the keys and become a transportation component for my parents or my aunts or uncles or whatever. We will have done them a major disservice. So we have to. It's imperative upon us of being on this board to go out and advocate and educate for this. And I'm glad that we won't be penalized for it. Thank you, Mr. Chair.
Thank you, Commissioner Newton. Commissioner Maroney, and then Commissioner Mertz, and Vice Chair Johnson.
Thank you. Commissioner Long, thank you for bringing back memories of legislative
I'm
days
so
gone
sorry.
by. And it's nice to have somebody here who actually did the bill that explained the intent of it to everyone, because it always comes up on issues. There's no doubt that there's misinformation being put out there, and most of the time you see it for those of us who are on Facebook. And Brad, what I was wondering, if you see that misinformation, are you allowed, and Alan, this is to you maybe, are you allowed to answer that from the PSTA Facebook account? Because you're probably paying for that with tax dollars, but your own personal account, would you be able to negate that incorrect information?
He could respond on PSA's Facebook, again, so long as he doesn't go that extra step and say, vote for, support Greenlight Pinellas, that type of
Those three
language.
those three
But
sentences.
if it's a factual, if he's trying to correct misinformation that is factual-based, he can certainly do that on PSTA's Facebook page.
Okay.
Thank you,
Great.
Commissioner Maroney. Commissioner Mertz?
Thank you, Mr. Chairman. First, Alan, it was an excellent presentation. Thank you. Thanks for everybody else's inputs, Commissioner Long as well. For someone like myself who hasn't been in it long, I very much appreciate that, to hear a little bit more about where it all came from. I just wanted to just add something back to what Brad just mentioned about the bookends. I think that's very, very important. But I think it's also got to be really important that you have a single page of details. That bookend report can't be so big that, because it covers, as we've all mentioned, pages and pages of information and many discussions. So it needs to be something that is a series of, good talking points that understand what's going on, present what we have, but it also is a living document, because there's going to be lots of disinformation and stuff coming on, so it needs to be addressed and reviewed quite periodically, and something that we can all get access to as part of our advocacy and discussing, so we can get a hold of that and be able to talk with it. But I think that's excellent to be looking into that.
Excellent point. The average Facebook user is not going to go through the details. They want something that's
Right.
bright and,
Quick summary.
bullet points.
Isn't that already on the Greenlight website? Most of that information?
It is, yeah.
Commissioner Johnson?
Thank you. And this discussion is leading into something that I hear from several people, when they have a different perception of, or there are different perceptions of reality about the Greenlight plan. For instance, I have a friend that was talking about the rail portion of the Greenlight plan, and saying, well, if you're just going to be putting in trolleys, then you're not going to be able to move very many people. Well, it's my understanding, we're not putting in small trolleys. It would be a full-blown light rail system, like the Portland light rail system, not like the Portland trolley system. But people, if they go to San Diego or someplace, they have a perception. So I think that perception of reality is going to be important as we move forward, visualizations. And at the same time, those visualizations, we need to be careful on how the visualizations are prepared. For instance, if a car is just depicted as a spot instead of as a regular car in a parking, we need to make sure that we're as realistic as possible with those drawings. And the other thing that I think is a little bit confusing to this process is we don't have all of the designs and the specifications for each of the stations and each of where the crossings are going to be. This is going to be a evolving process, particularly as we go through with the rail side. And I think the public would benefit by, if they want to drive down into that detail, to know what that process is going to be. That there's going to be a PD&E study, and it's going to take generally 2 years, or there's going to be a preliminary design, and there will be public comment opportunities through those, so they don't over manage their expectations or under. So I think we have a continuing job to do over the next year in both of those areas.
Okay, thank you. Commissioner Dighton?
I want to again thank Alan for his clarification on all this. I think we have established that it's very important that we have an education program. And I think what Alan has told us is that if we want to spend money educating people and not advocating, then it's perfectly within our duty and our rights. To that point, I am not aware of any money that we have budgeted for an education program. And I think we should take this subject up and set some money aside, find the money, so that we can adequately educate the public about what our position is. Because For certain, there's going to be a lot of information out there that's not correct. So I think that's a first order of business.
Should we task the planning committee with that?
That'd be a good idea.
And just a point of clarification, the adopted budget does include $150,000 in educational funds.
When is their next meeting?
February 19th, I think it was the,
Something like that.
And Commissioner Buljowski chairs that?
yes.
Okay, well, that ought to be, I think, a priority item,
Mhm.
to get the plan in place and get the plan together for education. Any other questions or comments? Thank you so much for updating us on this, we appreciate it. We'll move now to